Good afternoon or evening, good morning, depending upon where in the world you are. My name is Professor David Wilkins. I'm the Faculty Director of the Harvard Law School Center on the Legal Profession, which is a center that is dedicated to empirical research on lawyers and the legal profession around the world, and to bringing together lawyers and other important thought leaders to think about the role of lawyers in society and the important place that lawyers around the world serve in meeting the most important needs of society. It is my great pleasure today to welcome all of our many visitors from around the world, and we have a very large number of people watching us live, and many more will watch this once we post it online, to a celebration of the ascension of Justice D.Y. Chandrachud to becoming the 50th Chief Justice of India. It is a particular pleasure for me and for the Center of the Legal Profession to participate in this important event, because then Justice Chandrachud has been incredibly helpful and influential in the work that the center has been doing on the Indian legal profession now for more than a decade. Indeed, in 2012, now more than a decade ago, when we launched our project on globalization, lawyers, and emerging economies by taking a deep look at the Indian legal profession, it was then Justice Chandrachud who gave a brilliant keynote address here at Harvard to launch that project. In the intervening years, we had many opportunities to meet with the justice and to talk with him and to learn from him as we conducted the research that eventually ended up in our book entitled The Indian Legal Profession in the Age of Globalization: The Rise of the Corporate Legal Sector and Its Impact on Lawyers and Society. And when we launched the book, when we completed the book, we came to India for a series of events. And once again, then Justice Chandrachud, now Chief Justice Chandrachud, was our keynote speaker. We couldn't have imagined anyone better to frame the issues that we have been studying in that book in the larger context of India. I won't go into detail in Justice Chandrachud's many accomplishments because they are known by almost all of you. He's been a brilliant lawyer, an advocate, a judge on the Bombay High Court for many years now, a justice on the Supreme Court, and now, of course, elevated to India's 50th Chief Justice. He has been a stalwart defender of liberty, of freedom, of individual rights, of dignity, of all of the essential core elements of the rule of law that have made, quite frankly, the Indian judiciary and the Indian legal profession one of the most important in the world. He has done a huge amount to shed light on important issues facing the profession in ways that we will have a chance to discuss with the justice in just a minute, as well as with my colleague and co-author on our research in India, Vikramaditya Khanna, Professor Khanna, who is a professor at the University of Michigan Law School and really is, again, known to many of you as one of the leading experts on India. It's for this reason that the center has decided to bestow upon Chief Justice Chandrachud at this critical and important moment of his ascension, the center's highest award, which is the Award for Global Leadership. Justice Chandrachud really exemplifies all of the great qualities of a global leader of our profession. This is an award that has been bestowed in the past on U.S. Ambassador and Permanent Representative to the United Nations, Samantha Power, to Brad Smith, the Vice Chair and President of Microsoft, on Vernon Jordan, one of the leading lawyers of our generation, and an advisor to presidents, a senior partner in one of the premier law firms in the United States, as well as one of the premier financial institutions. And most recently, on Kenneth Frazier, the CEO, just recently stepped down CEO and chair of the global pharmaceutical company Merck. We are honored to bestow this on Justice Chandrachud because of his long and distinguished career and anticipation of all of the important things that he will do in his tenure as Chief Justice. Justice Chandrachud, in many ways, brings together the important parts of his own family background and has launched an incredibly distinguished family of his own. As most of you know, he is the inheritor of an incredible lineage of lawyering and in the judiciary. His father was India's 16th Chief Justice, but he also carries forward his mother's legacy, who is an incredibly accomplished musician and who gave to the justice a love of music that he continues to further and that nourishes him in the important work that he is doing and will do on the Supreme Court of India. He has an incredibly distinguished academic career. So the justice is a graduate of Delhi University, of St. Stephen's College, but I'm also proud to say he is a graduate of the Harvard Law School, getting his SJD degree in 2016 and winning the very prestigious Beale Prize for his thesis, which we will have a chance to discuss with him and the implications of that distinguished thesis in just a moment. He has also continued to stay engaged in the academic world, not just at Harvard, but lecturing all over the world and in India at many of the most prestigious universities. He has also stayed engaged in the cutting edge issues that really are influencing not just India, but really the world as we move into this pivotal new era as the world emerges from the COVID epidemic that has really burdened everyone in the world, but also perhaps opened up new ideas and new vistas about how we think about everything from courts to lawyering to justice to the rule of law. And we'll have a chance to speak with the justice about all of those important issues in just a moment. But on a personal note, I just want to emphasize that the Chief Justice, notwithstanding all of his accomplishments, is a man of tremendous warmth and humility. I've had the pleasure of being in the Chief Justice's home, of meeting his beautiful wife, Kampala, and their wonderful daughters. He also has two amazing sons who are now making distinguished legal careers in their own right. We've had a chance to have the Chief Justice here with us at Harvard, as I mentioned, both in my home, but perhaps even more importantly, with our students. And I've seen the way in which he has reached out to mentor the new generation. It is that spirit of openness, of giving, of engagement, of reverence for the rule of law and all that it entails that we know the Chief Justice will bring to his tenure in this critical position at this critical time in Indian history. And it is for this reason that we are so honored to bestow upon Mr. Chief Justice Chandrachud our award for global leadership. Mr. Chief Justice, let me welcome you to the virtual stage, and I would love it if you would turn on your camera, unmute your microphone, and perhaps give us a few words before we begin our conversation. Chief Justice Chandrachud.
Thank you very much for your warm words of welcome and kind introduction, Professor Wilkins. Very good evening to everyone in India, and a good morning to Professor David Wilkins, Professor Vikramaditya Khanna, and the members of the audience who've logged in from Cambridge and elsewhere. It is my distinct honor to be the recipient of the Award for Global Leadership presented by the Harvard Law School Center on the Legal Profession. This is a doubly special occasion for me because I spent many years at Harvard, first for my LLM and then for the SJD. As with many other students of Harvard Law School, my time there was transformative. I developed a deep appreciation for the conceptual dimensions of rights, jurisprudence, and both my practice of the law when I was a lawyer and the discharge of my duties as a judge have been grounded in that understanding. I therefore received this award with a sense of humility and a deep sense of commitment to my own work as the Chief Justice of India. I considered it to be not only a mark of recognition for my work in the past, but also a symbol of the faith placed in judges as I embark upon fulfilling my functions in the office over my tenure. As a judge of the highest constitutional court in India, my allegiance lies to the Constitution of India and to upholding constitutional values, the foremost of which is the rule of law. I believe that judges have a vital role in facilitating a legal order which is humane and places human dignity, liberty, and equality at the forefront. My sincere thanks to the Harvard Law School Center on the Legal Profession and to Professor David Wilkins for presenting this award to me. I only regret being unable to receive it in person in Cambridge. I have many fond memories of the Verdun campus, as it then was, and of time spent in the magnificent library of Langdale. And I look forward to being able to accept the center's invitation to visit in person sometime in the future. When I do, I will join Professor Wilkins, who is a prolific academic and a good friend, on a walk down Harvard Yard, where I'm sure we will have many more fruitful discussions on the legal profession. It is also my pleasure to be in conversation with Professor Vikramaditya Khanna today. But above all, thank you from the bottom of my heart for this recognition and award.
I should have known I was still on mute. Even though after 2 years of Zoom, I still make that mistake. As I was saying, Chief Justice Chandrachud, it is our honor to bestow this award on you. And I'm so grateful that we'll have the chance to have a conversation now, but look forward to many more conversations, both in Cambridge, but also in India, which is a country I have come to love very, very deeply. I want to start, though, our conversation with your time at Cambridge, our Cambridge, because many of those on this line may have studied at the other Cambridge in England, but our Cambridge at Harvard Law School, where you were, as I said, a very distinguished scholar and student, doing both your LLM and SJD degrees. I have to say, when I realized in just basically 2 years, and in 2 years, you produced a thesis, if you don't mind my holding up a prop, this is volume 1 of 350 pages, and there are another 350 pages in volume 2, but I couldn't quite lift it all. But it is an extraordinary achievement. And I know that you worked closely with 2 faculty members, one of whom, sadly, Professor John Mansfield, who was really known to many people here as one of the leading American scholars on India, on the Indian Constitution, on the Indian legal system, unfortunately is no longer with us. But the other, Professor Lance Liebman, who went on to become the dean at Columbia Law School, the president of the American Law Institute, and one of the leading scholars on property law and many other disciplines, is with us today. When I wrote Professor Liebman and told him we were doing this event, he said, of course, I remember now Chief Justice Chandrachud is an amazing student, and I wanted to be here, and asked me on his behalf to convey his congratulations for your amazing career, and that makes all of us affiliated with Harvard Law School very proud. Your thesis was really, like many things you have done, exceptionally prescient. You wrote your thesis on the protection of minority rights in India and the complex issues that raises philosophically, practically, legally, for all parts of society. And I know that this has been a deep and abiding interest of yours and passion of yours in the years since. And of course, as you know, it is an issue not just for India. It is an issue for many, many societies around the world, including, of course, my own here in the United States. And I wonder if you would just say a few words about where you see that issue today and what you think are the key questions or issues that we in the legal profession particularly ought to be thinking about with respect to this critical question.
Professor Wilkins, when I commenced my studies at Harvard Law School for the SJD, I came back, I came from a background of a law school which was very strong in terms of its commitment to public law, which was the Campus Law Center of Delhi University. And we had some remarkable teachers, Professor Latika Sarkar, Professor Upendra Bakshi, Dr. Arabi, who really kindled that fierce interest in public law and its interface with human rights. That really led to my evolving interest in the subject on which I eventually wrote. And a key element in that thought process was Dr. B. Sivramaya, who was teaching law and poverty in the Campus Law Center in Delhi. And I studied constitutional law at Harvard, and Professor John Mansfield, with his seminar on law and religion in India, was someone who really gave me a lot of insight and inspiration. And I'm so happy that Professor Lance Liebman is here. I mean, I really was delighted to hear that Professor Liebman, who was also my supervisor for the PhD thesis, for the SJD thesis, is here. Talking about the thesis and where it really leads us to current issues, I think the thesis begins with an analysis of the philosophical approaches to affirmative action. And it looks at affirmative action from the context of a more inclusive, a more humane society to right the wrongs of discrimination which have been perpetrated in our own societies over centuries. Looking forward, and that I think raises some critical questions for us today. And one of those questions which has been troubling me and on which I have written as a judge is, how do we think about merit? Because every time that we speak of affirmative action, the counterpoint which is set up is that, does this dilute merit? And I think that is an area where I have written both not only as a student, but now as a judge of the Supreme Court, which is that we need to completely reconsider and review our notions of merit. For instance, when you have admissions to law school, do scores on an aptitude test or an entrance test necessarily define how an individual would function or perform later on when vested with public responsibilities? So also, when we speak of affirmative action, I think that affirmative action should not be looked upon as a tolerable exclusion or exception to merit, but something which really fosters merit by bringing into the fold people who have the potential to discharge roles in every conceivable manner in society, but who have been excluded as a result of stereotypes and discrimination which is practiced in society. So I think we need to redefine the whole concept of merit completely in a way which makes accommodation for diverse viewpoints, diverse social backgrounds, and regards a society in which we have an inclusion of plural values as itself being something which promotes merit. So I think that is a key feature which I look to in the future as we think in terms of some of these ideas which have been explored in my thesis.
So, Chief Justice Chandrachud, I can't help but follow that brilliant and critical statement with just one little data point, and it comes actually from our friend Professor Khanna, who will be speaking to you later. His law school, not work he did, but done at his law school, in which the University of Michigan Law School did probably the most comprehensive study ever done, trying to correlate the scores on entrance exams, which in our case are the Law School Admission Council test, the LSAT, and the three things that the University of Michigan Law School says that it wants from its graduates, which are financial success, professional satisfaction, and public service. And it found that when you looked at the entering test scores of people coming into the law school and tracked those things comprehensively across many generations of students, that there was no statistically significant correlation between these two things, inputs and outputs, with one exception. It turns out that the LSAT scores were correlated with doing public service, only it was a negative correlation. The higher the LSAT, the less public service people did. Now, I'm not saying that definitively proves people with high test scores are not public-minded, but it certainly is not a ringing endorsement for the LSAT's predictive value, which you were presciently talking about back in 1986 and continue to talk about today. I want to talk about another thing, though, that you have been quite prescient about as well. I mentioned that in 2017 at the spectacular ballroom of the Taj Hotel in Delhi, where we launched our book. You gave a brilliant keynote address, and you talked about many things, some of which we'll come back to in a minute. But one of the things you touched on was the mental health of lawyers. And you said this, and I'm just going to read. You said there's an important issue that is neglected and rarely discussed in the legal profession: mental health for younger lawyers. Since many issues specific to the legal profession are responsible for the heightened level of stress that most of us have felt, general empathy and sensitivity to understand mental issues must be accompanied with a knowledge of the idiosyncrasies of our legal profession. Now, you said that in 2017. Since 2017, we've had an outpouring of interest in these issues precisely because we've all had to face the mental health challenges that have come with the pandemic, with the lockdowns, with the tragic loss of life. And I wonder how you're thinking about these issues now, particularly sort of from your perspective as one of the most public and influential voices in the legal profession, not only in India, but around the world.
Well, there are several causes of mental health issues which are very significant to the legal profession. The first and primary cause, I believe, is the adversarial tenor of the legal profession. I think there's something in our profession by which people pride the sense of adversarial tenor, as I said, in this profession, which makes the legal profession very stressful. Long hours, sleepless nights with no exercise, and financial worries, especially because of the prevalence of the pandemic and what has happened as a result of the pandemic. People lost work, people lost family, they lost friends. Junior lawyers, especially those who do not opt to work in law firms or in corporate law, are often not compensated sufficiently. Part of the reason for this is that the law in many countries is still a feudal profession. The law is a conservative profession, and it can be exclusionary of marginalized communities, including racial and caste minorities, women, the queer community, and persons with disabilities. Therefore, mental health has to be understood as a complex web of very interconnected factors. The importance of mental health in the legal profession is often there's a tendency to view the necessities of life from the lens of one's career. The question is not how can good mental health help advance my professional interests. Mental well-being, to my mind, is of paramount importance, even if it cannot advance your career in any way. It has an inherent value. In any case, it does improve your performance in the long run by just pursuing a holistic pattern of living. Now, we have created a system which rewards excellence at the cost of practically everything else. So it is necessary for us to reorientate and recalibrate the system, and the practice of law must become sustainable. Now, what is the solution, and how do we think about a solution? Basically, there has to be a change in mindset across the profession. Holistic well-being must be considered an essential part of a lawyer's life. We have to avoid the tendency to glorify overwork and burnout. That is a race to the bottom. The law firms, or almost every space, barristers' offices, must encourage a sense of professional camaraderie, kindness and sensitivity. Paying living wages. One of the great criticisms which have been expressed about lawyers' chambers in India, for instance, and I dare say the same in many other parts of the world, is that living wages are not paid to young lawyers. There have to be reasonable expectations within the profession on the importance of maintaining a work-life balance. But above all, I think we have to dispel the stigma which surrounds mental health issues. Each one of us has faced some sort of a mental health issue or the other at some point of time in life, or has the potential to face it. So it's important not to really stigmatize those who face these mental health issues. Fighting discrimination and exclusion within the profession is crucial. So it's important that we adopt an intersectional approach to caring for mental health, particularly in the context of the very stressful environment which lawyers have to confront in the profession.
That is so well said, Chief Justice, and it's something that we at Harvard Law School have experienced, every legal organization that I know has experienced, and frankly, changing this is essential to continuing to attract the best and the brightest young people into our profession, which after all is critical for everything that we need to do. That leads me to another issue, which you've also been quite prescient on, and which we've all been forced to look at in a much more intense way over the last few years, and that's technology. One of the things that we know is that technology has reshaped and been reshaping everything about our societies for many years, including the legal profession, but the legal profession, quite frankly, has been slow to embrace many of these issues until it had to. And in 2021, shortly after perhaps either the end of 20 or 21, I can't quite remember when we did this, we did a webinar on online courts in which we looked at the book that Professor Richard Susskind had written, also presciently, about these issues, which he published in January of 2020, right? As a hypothetical exercise, right before every court in the world went virtual after the pandemic. And after some discussion with Professor Susskind and other engagement with lawyers, we asked you if you would ask a question and frame some of these issues from the perspective of the Indian context, because we knew that you had already begun thinking quite seriously about how technology will impact courts, the rule of law, the practice of law, and everything about our profession. And now you've had another 2 years to consider these questions, as also courts are opening back up for in-person hearings. And yet, as with most other things in the legal profession, no one thinks we're going to go back totally to the way we were doing things before. So I wonder how you think about how technology is going to reshape the courts during your tenure as Chief Justice and the legal profession as well.
Well, as Professor Susskind says in his book, the real challenge before us today is to go beyond merely using technology to substitute our paper-based processes into the electronic form, and to use technology to bring about a digital transformation. And that involves really a transformation of thinking as well. Now, there is undeniably a positive correlation between technology and access to justice. And we realized that during the COVID-19 pandemic, because when the pandemic descended on us, my Chief Justice called me to his chamber and said, we have to shut down the courts if we don't do something which is a substitute. So we used all the courtroom infrastructure which we had in terms of our desktops, our microphones, the inbuilt cameras, and we started virtual hearings. And right through the pandemic in India, we provided access to justice through virtual hearings because the courts couldn't have shut down. We had to hear bails and we had to hear urgent matters where there were arbitrary arrests and ensure that human liberty is secured. So it is imperative for us at the same time to recognize the digital divide and bridge the gap. Because while we realize the benefits of technology, we must ensure that no one is left behind. The benefit of virtual hearings through the pandemic is that in the traditional sense, litigants from across the country have been able to participate in our proceedings. The Supreme Court is no longer a Supreme Court which is just located and situated in Delhi, but truly a Supreme Court for the entire nation. A more novel outcome has been that lawyers from different backgrounds appear with ease. For example, more women have been appearing during the virtual hearings during the course of the life lockdown. Just last week, we have enhanced our mission to provide access to justice by launching the e-SCR, the e-Supreme Court reports. We have a repository of 34,000 judgments of the Indian Supreme Court from 1950 to 2022, and now, of course, 2023, which have been made available with an elastic search facility to lawyers, citizens, researchers, academics across India and the world. So lawyers, young lawyers, do not have to pay private companies to access our judgments, which promotes financial accessibility. We are moving now to live streaming of proceedings before the Supreme Court, which I believe would aid transparency. When citizens across the country look at the serious business of legal work which goes on in the Supreme Court, I think it promotes a sense of confidence in the work which judges do and the kind of impact it has on the lives of citizens. There are other technology-driven initiatives. I don't want to take too long on this, but I'll just mention a few. We have virtual hearings. We are on the anvil of electronic filing of cases in the Supreme Court, paperless courts, where judges and lawyers will rely on digitized court records. We have tried to curb the digital divide by setting up help centers, which will be established in each one of the 17,000 courts in India to assist litigants in using technology, digitization of hard copies of case files, serving processes electronically, and virtual courts for compounding petty offenses, which affect the lives of common citizens. So I do believe that technology really is replete with potential. Artificial intelligence can be conveniently deployed, and machine learning, for instance, can be conveniently deployed to ensure that though our language of discourse in the Supreme Court and in the high courts is in English, that our judgments are made available in all the Indian languages to citizens across India, so that we reach out to citizens. So the last point which I want to make on this is that technology gives us an opportunity to replace the colonial model of justice, which was that citizens must reach out to justice, and replace that with a model where justice services across the country reach out to citizens, which I do believe is the real potential which technology can help us to realize.
That's so critical, particularly in India, but also in my country, given the barriers to access to justice and the backlog of cases, all of these things, the hope is technology can help with. Let me ask just one final question before I bring in my colleague, Professor Khanna, who really is an expert on so many things about Indian law. But one of the main features of our book was legal education. And that was a main part of your keynote address when we launched the book in 2017. And I wonder, again, from the perspective now of a few more years of thinking about this, and again, thinking about your role as Chief Justice of kind of in the Indian legal profession and Indian legal education, where do you see legal education going in the next few years?
Professor Wilkins, I think there's no better place than a law school to implement the ideas surrounding some of the themes which we are discussing today, from mental health to the representation of marginalized communities in the legal profession, because the culture of a law school often becomes the culture that a young lawyer perpetuates in a more professional setting. Besides training students in the art of thinking like a lawyer, law schools inculcate the spirit of inquiry, as well as impart a respect for the traditions of the legal profession. Law schools also introduce students to legal ethics and to legal philosophy. They teach students advocacy and legal writing and expose them to a variety of cultures and practices quite different from their own. So law school in that sense presents a huge learning curve for young students to live out of their immediately lived experiences of life and look at a much wider world and community outside. And that, I think, is an important facilitator to promoting a society which is more inclusive and accommodative of plural cultures and interests. Unfortunately, the legal profession, as I said a short while ago, has been feudalistic. It has not been welcoming of women, of people from marginalized backgrounds. And I think that law school education, by democratizing access to education, has a vital role to play in broadening that sense of access to the legal profession. And the impact of that would be felt, say, 3 or 4 or 5 decades from now. A lot of times this question is posed to me, why don't you have more women judges in the Indian Supreme Court? And of course, my ideal in that is RBG, because she was asked, well, when would you be content with a sufficient number of women judges in the US Supreme Court? And she said, well, that would be when there are 9. So, when I'm asked this question about why don't you have more women judges in the Supreme Court, the answer to that lies in the profession as it was, say, 3 decades or maybe a little more previously, because the pool of people coming to the Supreme Court today, or the pool of judges coming to the Supreme Court or the high courts today, is drawn from the profession as it began for them 2 or 3 decades ago. So unless we change the foundational values of the legal profession now, we'll not be able to move towards a more inclusive legal profession in the future. And from that perspective, law schools have a very vital role to play. And I do believe that the very important feature of legal education today is to draw in students from diverse backgrounds. I see that in my own judicial clerks who come and work for me. And I find that so many of them are absolutely unconnected in terms of family contact with the law, students who are the first generation lawyers, and who come into the profession with a great deal of promise and expectation. Now, the challenge is when they enter the legal profession, how do we mentor them and ensure that that promise and potential is fully realized, which is, of course, a very complex issue. I mean, that can merit a separate discussion in a seminar. But there is therefore this very deep connect between how we facilitate access to legal education to how we eventually facilitate a more equitable access to lawyering assignments and eventually to judgeships in the legal profession in the future.
Well, Chief Justice, that's one of the many reasons why we're so excited that we will continue to be able to engage with you about legal education, both in the US and in India. And I know since we share a common mentee who is actually on this call somewhere, Anurag Bhaskar, who is your law clerk and my student, who exemplifies exactly all the potential that you just said. I know you practice what you preach, as we say. But I'd now like to bring in my dear friend and colleague and really teacher about India, Professor Vikramaditya Khanna, who is the William W. Cook Professor of Law at the University of Michigan, a faculty affiliate of the Center on the Legal Profession. And during our many years of working on our book in India, the best tour guide you could have ever on the history and culture of India. Professor Khanna, I know that I have been studying Justice Chandrachud and the Indian judiciary and legal profession, and I wonder if you could ask a few questions of the new Chief Justice.
Thank you, Professor Wilkins, for that extremely generous introduction. And good evening, Honorable Chief Justice Dr. Chandrachud. I'm honored to join you all this evening, afternoon, and morning. And I'm thrilled to speak with the Honorable Chief Justice again. I'm particularly delighted because I've always enjoyed reading the Chief Justice's opinions. They are exemplars of erudition and elegance, and they have had significant effects on the development of law in India, securing justice, and on my own thinking. With so many topics of importance, I feel almost like a child in a candy store. But I thought I would begin with a recent topic and decision. Just this September, Chief Justice, you authored a decision that expanded abortion access in India, X versus the Principal Secretary, Health and Family Welfare Department. We would love to have your thoughts about the decision in a global context.
Thank you, Professor Khanna. That decision really was rooted in the constitutional values of dignity and reproductive autonomy, as well as India's obligations under international law. What the judgment dealt with was precisely this. The statute recognized a right to abortion up to a particular period for all women, but then gave an extended period for women who were not single, essentially women who are in a marital relationship. That was a question before us in the context of a young woman who had a near-term pregnancy and she wanted to abort. Now, judicial decisions are the proverbial first step in the journey of 1,000 miles. Much remains to be done to enforce and perfect these rights on the ground. When the case came up before us, the first thing that we had to do was to do justice to the litigant who was before us, to do justice to the human being who was before us. And she was running out of time. So we allowed her to be examined on her request at a government hospital here in Delhi, the All India Institute of Medical Sciences. And they submitted a report to us that having an abortion would not pose a danger to her life. We were very deeply concerned about whether her life would be in danger if you were to abort. And once we got the report that the abortion would not pose a danger to her life, we held that, well, she was entitled to her reproductive choice and autonomy. The rights which have been recognized in judgments like this continue to remain a pipe dream for many marginalized groups even today, which is really a sobering reflection for us as judges. Globally speaking, abortion has been a sensitive issue because of cultural and religious factors. Courts in many countries will be called upon to decide such issues, and they will be required to abide by their own respective laws. However, many of these countries would be signatories to international instruments such as the International Convention on Civil and Political Rights and CEDAW. Crucial it is to use these instruments as a guiding light or a lodestar. And without really sounding patronizing at all, so the furthest in my mind to say that, I think many Western democracies only look to developments in each other's jurisdictions while interpreting the law. But perhaps it is time to look at jurisdictions in the global South for seeking some inspiration on innovative legal thinking or a more dynamic interpretation. And fostering a greater respect for inalienable rights. Because I did believe, and I do believe even now, that while deciding the abortion case recently, that reproductive autonomy and the control of a woman over her own body and mind are crucial to the constitutional goal of realizing human dignity. And this is just non-negotiable. We've tried to expound upon this, not just in the abortion context, but on various facets, such as the entry of women into the armed forces. The theme is the same, basically, which is that we recognize that the element of autonomy resides within each woman, entitling her to take crucial decisions on these vital aspects of her own well-being, which are crucial to realizing a constitutional culture based on the realization of rights.
Thank you, Chief Justice. That's a very humane and important decision that you've described for us. In your sense, what are some additional steps that one might expect, or maybe not expect, but anticipate being important to encourage the kind of flourishing that you've been talking about for all people in India?
Professor Khanna, I mean, I'm a judge, and I spent the better part of my working life as a lawyer and as a judge. But I also believe that it's important that while we do depend upon courts to realize rights, the journey in the realization of rights does not begin and end with courts, because there is life beyond the law, and there's life beyond the courts and the legal profession. And I think it's important that we engage with common citizens in making them aware of the rights that they have, in forging bonds of commonality, of forging bonds of staying together, because marginalization, be it in the context of reproductive autonomy or other human rights, is not isolated. Marginalization affects groups of our citizens. And I think this bonding together of citizens, bringing together of citizens is crucial in the realization of rights as we go forward. And therefore, I place a great deal of importance on social movements which thrive on the law, social movements which also utilize the instrument of the law for fostering greater realization of human rights, but at the same time, look beyond the law as well for the realization of rights, because courts do have their limitations in terms of the nature of the reliefs which we can grant. And I think, therefore, there's always that scope for expansion of the boundaries of what can be realized through courts by social movements and active engagement, both at the intellectual levels in forums such as law schools and the wider community beyond as well.
Thank you. That's wonderful. I thought I might also move on to another topic that is very, very dear to my heart, the role of scholarly articles in court decisions. As a professor, I'm always keen to hear the views of accomplished jurists on this topic, but you, Mr. Chief Justice, are yourself an accomplished scholar. And so I'd be very interested in your thoughts. Can you give some examples from your own judgments where you have relied on scholarly articles to reach a decision?
Well, I can think of three examples where I've relied upon on comparative law, particularly on scholarly articles. The first, of course, is the decision where we recognize that privacy is a fundamental right under our Constitution. The Indian Constitution does not have privacy as an enumerated fundamental right. And the question before us was whether privacy still can be recognized as a fundamental right. And we grounded that in the right to life and personal liberty and a whole host of rights in the chapter on fundamental rights in our Constitution. In deciding that case, we relied, which was reported as, the Justice K.S. Puttaswamy case, we relied upon scholarly articles from different jurisdictions. The second was our judgment where we decriminalized homosexuality. That is the Navteej Singh Johar case, where again, we've looked at perspectives beyond India, perspectives, of course, within India, but beyond India as well. And the third area was in the context of affirmative action, where we sought to explore the contours of merit in a case concerning affirmative action. And in trying to understand what constitutes merit, we've looked at scholarly articles to sort of expound upon the whole notion of merit. So my point really is that the persuasive value of an argument ought not to differ on the basis of whether an advocate is making a submission or an academic or a policymaker has written a paper. These are just different means of communicating ideas, and each idea, therefore, has to be evaluated on its own merit. Scholarly articles are also a confluence of theory and practice, and can be an important source of discussion of legal issues and innovative thinking. These articles, scholarly articles, can help trace legal history because some of them identify issues and nuances long before those issues and nuances have even reached courts of law and courts of justice. But in fact, it is not just scholarly articles, but to my mind, art, poetry, literature as well, that can illuminate the path to be taken, because they are cultural edifices which breathe life into the black letter of the law and help us judge compassionately. In my judgment, while decriminalizing homosexuality, I quoted from a favorite poem by Leonard Cohen. And of course, it's also been set to music. But that's just an indicator that I think we need to look beyond just the black letter of the law, because what happens outside the law tells us so much about social issues which we confront as lawyers and as judges.
So wisely put, law is a part of the entire social fabric, and that makes for kind of holistic approach you're talking about. It is indeed impressive when one looks at the Puttaswamy decision and the Navtej decision, the extent of both scholarly reference, but also comparative reference that you make, which is really quite impressive and very enlightening in your decisions. Do you anticipate greater use of comparative materials in judicial decisions?
Well, yes, I think there is going to be this expansion of the use of comparative materials because, the world is really one globe. There's one global village. I mean, there is, of course, now a little bit of going back on the notion of a globalized liberal world order, which you see happening in diverse societies across the world. But notwithstanding that, these are cycles. I think this is cyclical. But at the same time, I think technology has brought us together. The ease of travel has brought us together. The Internet of Things has brought us together. And I think just all these influences which have shaped our lives, social media has brought us all so very close. Social media has flip sides, of course, but it's one of those instruments which has really completely changed the way we live, learn, and think. So I think willy-nilly, the impact of the kind of world in which we live, which is so deeply interconnected, leads us to imbibe ideas from across the world. I don't think any one of our societies can live in a silo, and our lives are really enriched by sharing, by talking to others. As a judge, I must share this personal experience. Judges lead very isolated lives because we are lost in our work. We have to read our files for the caseload for the next day. And there's a huge volume of work which we have to do. And besides, the nature of our offices requires us to maintain our sense of independence by staying aloof from society. Now, that's one of the flip sides of judging, which is the sense of isolation which it breeds. And that sense of isolation, which is actually a danger to robust judging, can be overcome if we look beyond the confines of just the law and our immediate work in finding answers and finding solutions, or just for that matter, finding solace for our souls, because looking at how other people have approached similar problems gives a sense of comfort that we are not alone in the work which we do. And the sense of comfort that we are not alone in the work which we do fosters a sense of optimism about life. Because a lot of times in the work which we do as judges, we face intractable challenges. And these kind of challenges are liable to breed a sense of cynicism about the potential of law to change society for the better. And I think one of the grave dangers that can confront any position of responsibility in society is that when you allow cynicism to take the better of your work. And my answer, personally speaking, has been to connect with people I know in terms of their written work, to connect with people I don't know except through their written work, be it in terms of their music, in terms of their art, in terms of their paintings, in terms of their poetry, because that gives you a sense that deep down, we are all connected by one bond of humanity, irrespective of what societies we live in or what time we live in and what cultures we live our lives in. There is this element of humanity which binds us together.
Thank you, Mr. Chief Justice. That was a wonderful answer.
So, Mr. Chief Justice, you have, of course, said it better than I ever could, why we are so honored to bestow this Global Leadership Award on you. You have so eloquently spoken, not just now, but for so many years, and we anticipate so many years into the future, about the importance of understanding that we are all knitted together as part of a global family, notwithstanding all of our challenges and differences. It is why we are so honored that we have been able to spend this time with you today. I want to thank Professor Khanna, who, as you can see, really is a wonderful friend and expert on India and of India and bringing India to the world. I want to extend a special thanks to your team at your office for helping to facilitate this, including our mutual student, Anurag Bhaskar, who's now an assistant professor at Jindal Global Law School, another institution begun by a Harvard Law School graduate, I'm proud to say, but also working closely with you. I want to thank your family for giving us this time and your precious family time to be able to engage in this conversation with us and with the thousands of people around the world, around India and the US and elsewhere who will be watching this. But mostly I want to thank you. You will recall that when we first met, I told you that we wanted to write this book about India, which I'm very proud that we have, and it's available in India for anyone who wants to see our work. But I promised you that the publication of the book would be the beginning, not the end, of our engagement with your great country and our learning from all of the things that you have so eloquently talked about, that we in the United States can learn from what's happening in India. I look forward to continuing this conversation, hopefully in person when we can give you the award again. We actually have a physical little thing that you can put on your desk, we hope, to symbolize our respect and accomplishment for you. But mostly we look forward to watching your Chief Justiceship and learning so much from you and the humanity that you bring to your work. Thank you very much. Thanks to all.
Thank you very much. Thank you. Thank you, Professor Wilkins. Thank you, Professor Khanna.
Thank you. We will see everyone soon. Thank you.
Thank you.